Oyez, yea, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-7134. Ann Davis on behalf of Braden Davis, appellant, versus District of Columbia, a municipal corporation. Ms. Savitt for the appellant, Ms. Lassat for the appellee.
Good morning.
Morning. Morning, may it please the court. I am Diana Savitt, appearing on behalf of Ann Davis, who acts on behalf of her son, Braden Davis. With me this morning is Charles Moran, co-counsel for Ms. Davis, and Craig Lee, counsel for the Niki Curia, Advocates for Justice and Education, and counsel of parents, advocates, and attorneys. Mr. Lee has filed an amicus brief, and if the court has questions for him, he can answer them. We are not, however, sharing.
Okay.
And then with the court's permission, I will reserve 3 minutes for.
Okay, thank you.
The Supreme Court held in Board of Education versus Rowley that the purpose of the Individuals with Disabilities Education Act is to open the doors of education to students with disabilities. The Supreme Court held in the Andrew F. case that in enacting IDEA, Congress was concerned with eliminating the practice of warehousing these difficult to educate students until they just aged out of the educational system. We are here today because the district court denied a preliminary injunction to maintain Braden Davis in his current educational placement and thereby frustrated both of these statutory purposes, as well as specific language in the IDEA that mandated entry of the injunction, which is colloquially known as a state injunction.
Now, we are facing some novel circumstances in this case, in
Yes,
that
we are.
the facility is no longer available, but I don't suggest that that means that the district doesn't still have its obligation under the IDEA. So how should we tread ground in these novel circumstances?
Yes, the specific facility was not available. It discharged Braden. That does not mean that a comparable facility or arrangement could not have been implemented for him, far beyond what the district offered to him.
And by comparable, you're not suggesting that the hotel arrangement would be suitable here?
The hotel arrangement was a desperation measure on the part of the parents. They were justifiably concerned about simply bringing Braden home. They knew that in the past, when he had lived with them, he had engaged in highly dangerous activities. It remains an attractive nuisance for him. And so with no place else to go, they chose what they felt was their only option on very short notice.
So let me ask counsel, is it your position that the hearing officer's decision and what he ordered was also insufficient?
It was much better, but yes, it was insufficient because what he ordered on an interim basis was for the district to provide a day program for Braden. None of the residential components, including none of the therapeutic supports, none of the behavioral supports, none of the functional living skills work. So while what he ordered was certainly better than what the district had proposed, which was send him home and the parents do everything, it remains insufficient.
So is it your position that your only way to address that is to file the stay put motion as to opposed to seeking some sort of injunction?
Well, the stay put motion would have maintained Braden's placement until we could reach the merits, which is
where would it have made his place? Where would it have retained his placement? Or maybe
well, there were a few options. The first option would have been for the district to simply replicate.
what are the options?
Well, the first one would have been for the district to replicate what CSAC was doing. CSAC had him in a rented house.
No, I
No.
understand. So what is your view of your legal remedy at that point where you're dissatisfied with the hearing officer? I gather you thought it was to file a stay put motion?
Oh, no, I'm sorry, Ron, I misunderstood your question. We have appealed the hearing officer's decision to the district court. But the district court has stayed that proceeding pending this court's decision.
And denied it your motion to unseal as well. Is that not correct?
That is correct. Over the district's opposition, district recommended and the district court accepted that recommendation to await this court's decision.
So the hearing officer looked to the Fourth Circuit decision as offering a somewhat comparable situation. And I mean, you're the expert in this area. I'm just trying to understand what your legal options were once the district court denied your motion to stay.
Well, our legal options at that point were to muddle through, as the Davises did with the current situation, or for the Davises to unilaterally place Braden if they were able to find a place themselves, and they did search quite diligently.
No, what I meant was what court options in terms of your legal options.
Once the stay put was denied, the option was
No, I'm sorry. I want to be clear. At the point that the district court denied the stay put in motion, what were your legal options to appeal or modify that?
we took this appeal.
Yes, and the problem with it, I mean, I think everyone's in agreement on this, aren't they? Except maybe the district court, that granting your stay put doesn't solve the problem.
It wouldn't completely solve the problem if what you're insisting upon is placement in a private residential treatment center and therefore depending on a third party to admit him.
Now, is it your view that the district school system is incorrect in saying that it has looked for another such facility and not been able to find it throughout the United States, and that there is generally a glut problem that's facing persons like the Davis's son?
We know that the district made referrals to 19 residential treatment facilities as of the day the court heard the preliminary injunction hearing. All 19 ultimately said no for various reasons. Some didn't have space, some said he was not appropriate, some were not taking people because of COVID. To our knowledge, no further referrals have been made since then. At least the Davises have not been notified.
So I thought, yes, what I'm trying to understand is literally what are your legal options? The stay put motion seems to be serving another function, and it isn't going to solve the Davis's problem.
The stay put motion had been granted, had the district court exercised its equitable powers, could still have resulted in Braden getting most of the program that he is entitled to under his IEP.
Now, the equitable powers that you're referring to arise in the context of a civil action as opposed to a motion for a stay put order.
They are found in the civil action section, but the courts have exercised equitable powers in the stay put motions as well. For example, in the Alston case, in the GB case, both of which are cited in our brief, which were from the district court below. They have directed the district in the Alston case, the student was discharged from a residential placement. It was no longer available.
So
And the
can you cite any other circuit case taking that position on a stay put motion in comparable circumstances?
The district court, I believe, not a circuit case, the district
That's
court.
correct. So the district court may be in dispute about this, but at this point, what do we do? That's all I'm trying to understand. And as I read, the bottom line is basically looking at what the district court did here. You want the district court basically to convert that motion into a civil action and exercise equitable powers, or reverse its denial of your motion to lift, no longer hold the case in abeyance.
Well, the district court did not need to go that far. Under the authority of the Knight case that this court decided many years ago, what the district owed Braden, if his placement was no longer available, was similar services, not defined specifically in Knight. But what the district court could have ordered under that authority was the basic components of Braden's program to be provided to him directly by the district. There were other problems with what happened following the CSAC discharge, besides simply not giving Braden a new place to live other than the family home. One was, of course, he was sent home, which is a different level of restrictiveness on the IDEA continuum. Another problem was...
Ask you, so I understand that Braden's parents have cobbled together something that's similar to what they think he needs, using a hotel room and arranging their own round-the-clock supervision. Are you suggesting that the district should have put together something like that independently, or that the district should reimburse Braden's parents for what they've done? Like, what are you trying to get in the interim? Because I think it's undisputed that everybody agrees on what he needs and what the IEP is, and the district is looking for that and have not been able to locate it.
Well,
so what is it that you want in the interim?
Okay, well, whether the district is actually still looking for it is not clear from the record. But what we wanted was for the district to assume the responsibility for providing the components of Braden's IEP. The request was never specifically put him in a hotel. The request was to have the district continue to provide his services.
So basically cobbled together just as the parents did, but the district should do it. So, but let me ask you this. So why did you bring this under the stay put injunction provision instead of just moving for a preliminary injunction saying that he's being deprived of his fair education?
We do not believe that the traditional preliminary injunction was the appropriate avenue because he satisfied the grounds for stay put.
Well, I think it's procedurally a little bit more difficult under stay put, which is intended to address a different situation.
Well,
it seems to me that stay put is to address when the school wants to change or the school district wants to change the placement, there's a dispute with the parents, the child stays in the current placement until that's resolved. Here, through no fault of the district, this private institution decided that Braden couldn't have a space there anymore. The district is looking for a comparable space, and it seems to me what you're asking for, which is a comparable place until the permanent placement is found or the more long-term placement is found, is more appropriately addressed as just a preliminary injunction to say the district needs to provide a fair and appropriate public education until that is done. Whereas the stay put provision, it requires us to read into current placement all kinds of things that there's no precedent for right now.
There is precedent. There's
not direct precedent.
There's the Knight case also by...
But Knight wasn't exactly on all fours with that.
It's not on all fours, but it does say provide similar program. Also, the separate problem, and this was a huge problem highlighted in the state's declarations, under the Boost case, the district cannot transfer to the parents its obligations to implement the IEP. So we're not
No,
asking.
I'm agreeing with that. Even if that is the remedy that you're entitled to, why didn't you bring it under a preliminary injunction?
We did not believe that that the traditional preliminary injunction was the appropriate action because the
Why didn't you
Davises,
bring both in the alternative?
the Davises were not seeking to change Braden's placement. They were not seeking to change the IEP. They were not challenging. They were simply asking that the current IEP be implemented in as similar a fashion as possible. And to file the four-part injunction, they would have had to prove that they would have been asking for a change in the placement. And that
Why is that a change? My question is premised on the idea that what you're looking for is, while the district is looking for a more long-term placement in the interim, Braden is entitled to have the elements of his IEP met. And it seems to me that procedurally, and based on the case law, it seems to be relying more on the FAPE sort of premise as opposed to the stay put premise in saying that you're entitled to the same placement in the interim. It just seems to me procedurally to make more sense for you to proceed under a preliminary injunction posture. And I'm just wondering why you did not, because you're asking us to sort of make new law here and extend from where we are now on stay put injunctions, extend it to something where we haven't held that before.
Well, this was a highly unusual situation. I see I've run out of my time. Because the Davises wanted what Braden already had. A stay put injunction simply says maintain the current placement, and they wanted the current placement. If it could not be provided fully.
But the thing is, everybody agrees that he's entitled to that.
But his placement had already been changed when the district, when CSAC discharged him, CSAC, which was the district's agent for the implementation of his IEP, they discharged him, and the district said, take him home and provide everything for him until we find something new. So his placement had already been changed. What the Davises wanted was to bring it back to something closer to what his IEP called for. And that was a stay put request.
I think that's the question here. I understand what they wanted. I'm just trying to understand what's the best procedural way to get at what they wanted. And if I don't think it's the stay put injunction, then it would be a preliminary injunction. But you didn't ask for that.
No, we did not file that because we believed that the stay put injunction was the appropriate remedy for him. The stay put injunction was denied because the district court read into section 1415J a provision that is not there, which is that the current placement shall be maintained only if it is available. And under Honig versus Doe, you don't add to that section what is not in it already.
Right. That's not my concern. My concern is I understand what you want. And even if he's entitled to it, I don't know if stay put is the way to get at it.
Well, as I said, we were not looking to change the placement. We were looking to maintain the placement in as similar a fashion as could be achieved. And certainly.
No, we understand your position on that, but suppose this court were to disagree, then where are you? And what are your options?
Well, I suppose we go back to the district court where we have a complaint pending, and we litigate the appeal from the hearing officer's determination and litigate the issues arising from the fact that he issued some favorable rulings for the Davises that have not yet been complied with. And so we would litigate that.
And has there been any finding that the child cannot stay home and receive those services there?
It's been extremely rocky, Your Honor. He is, in fact, at home now. The hotel did not work out. And he's been living at home for about a year now, and it's been very, very difficult. He receives almost nothing of the authorized services because of difficulties with virtual services, with transportation, with payments. with just the Davis's time serving as effectively his aides, because they only are authorized for 8 hours a day, of roughly 5 days a week. So he's getting some instruction, not much else. But there have been many incidents since then.
And the search is, you said, not ongoing, or what's
To
happening?
our knowledge, there is no search underway. What has happened, I can tell you what has happened. In October, two things happened. The first was that Bancroft, to which the district had referred Braden a year earlier, did have a place for him and offered it to him, but in their adult program, not in their school, because he's too old for their school. The district has declined to place him there for various reasons. Also in October, a day program, the Alternative Paths Training School, offered him a program on an interim basis, consistent with the hearing officer's determination, which had been placed within 21 school days. This was late. The Davises were willing to accept that as an interim placement, but there have been huge problems with arranging transportation to get him there, and therefore he never started. So those are the only two things that have happened.
But I just asked you, what do you mean transportation problems?
There were problems unique to Braden and systemic problems. The Office of the State Superintendent of Education, which runs the special education transportation system, is experiencing systemic failures. Their routes are substantially delayed. Students are taking 2 to 3 hours to get to school and to get home again. Because of Braden's unique characteristics, it was not a good idea to have him on the bus for that long. And then there were issues about whether the aide who would be assigned to be with him on the bus was sufficient. He has very specific needs regarding the aide. His behavior intervention plan calls for an aide who is trained in a particular type of restraint called MAT. The Office of the State Superintendent puts aides on buses with instructions not to place hands on the students. That if they become uproarious, the bus is to be pulled over to the side, and the police call. Braden now being 22, there was tremendous fear that if the police were called, he'd find himself in the adult criminal justice system. And so they were quite worried about that. So there were unique problems for Braden. There's a systemic problem, and as a result, they were not able to take advantage of this day program, and so they elected to unilaterally place him at Bancroft at their own expense, and he has been there 1 week. And as I understand, he had a somewhat rocky start, but he's still there. So that is where we are, but we are not aware of any further searches by the district, or at least no referrals. I believe the Davises are notified by the district when it makes a referral, but not necessarily when it makes a contact that it then chooses not to pursue.
So on remand, you would not be precluded from moving for a preliminary injunction.
I'm sorry, I didn't hear you, Your Honor.
On remand, you could move for a preliminary injunction.
We certainly could.
Mm-hmm.
I see I've run out my time, so I've
you.
gone way over, so,
Well, you've been answering our questions. You'll still have time for rebuttal.
okay.
Okay.
If the court has more questions?
Not at this time.
May it please the court, Sonia Lepsak for the District of Columbia. The district acknowledges its obligation to identify a residential treatment center for Braden that can provide him with a free, appropriate public education, commonly known as a FAPE.
And why are you not currently looking for placements and making referrals?
The district is engaged in a thorough and ongoing search for a residential treatment center. The district differs from my friend's characterization of the search. Is ongoing. I've been part of those conversations, and the district continues to look for a residential treatment center. And this was
So have you gone beyond the 19?
Yes, The 19 that were sort of promptly identified and that are in the record on this court, the district court found that it was undisputed that this was an adequate search. And I would point the court most recently to the March 2022 decision by the hearing officer, who heard an even further developed record and found again that the district had, I think the words were sort of diligently tried to overcome the obstacles of residential treatment centers not admitting Braden. And the record before the hearing officer, I think 30 residential treatment centers have been identified and referrals had gone out, and there'd sort of been a process about them. And this is March 2022. So every
What is the problem? Is it his age? Is it
his age is a factor. His particular needs, including sort of fulfilling all of the obligations of the IEP, are a factor. The sort of vacancies at residential treatment centers that might be able to serve him are a factor.
But the parents are also suggesting that even if Davis was at home, the additional services required for behavioral issues, the other things attended to the plan, those are not even being met at home.
That's right. I mean, a residential treatment center is a highly specialized facility. These facilities are built, they're furnished, they're staffed with the particular disability of the population that they serve.
So when you said that's right, does that mean you don't feel that there's any obligation that under this interim circumstance that you have to provide the treatment providers to the parents' home?
Well, I think here, any obligation like that would surface through the FAPE denial claim. And that's exactly how it's happened here. The hearing officer has ordered an interim placement as part of the appropriate relief for the FAPE denial that the hearing officer found. And so I think that is, I think, a good example of the way that the IDEA handles remedies for FAPE denial. And that's very different from a stay put injunction, which is a limited procedural safeguard. All it does is decide, while a dispute is pending, which educational placement prevails. And the stay put provision says, it's like a switch in the railroad. It says, the then current educational placement prevails. School authorities can no longer exclude disabled children from public education unilaterally. Instead, they have to vet their new placement, whatever it may be, through due process procedures. In the meantime, the child stays put. And the place that the child stays put is in the then current educational placement. And so stay put is serving a very different and important but limited function from the overall substantive guarantee of the IDEA. Where Davis has already received relief is through that substantive guarantee. The hearing officer has heard the FAPE denial claim. It has ordered a number of remedies, not just the interim day school, but also ordered the district to continue searching. Again, that is in fact happening. And at Davis's request, the compensatory education request has been deferred. But compensatory education is certainly part of the remedy for a FAPE denial claim. In fact, it's the proper remedy, and it's the usual one. I think what Davis seeks to do here is essentially duplicate the IDEA's substantive guarantee in a stay put posture. And this is an extreme and novel claim. To my knowledge, it has no support anywhere in the federal courts of appeals. And it's actually unnecessary, because what the IDEA substantive guarantee does is it takes care of this very problem. And I think, Judge Pan, you mentioned, isn't the right thing procedurally here a preliminary injunction? Precisely right. That is one procedural way to get the thing the Davises are asking for. But they haven't pursued that here. For more than a year, they have not pursued a preliminary injunction at all. But I'll say that there's also other remedies under the IDEA. One is that Davises could agree with the district on an interim placement. Agreement is part and parcel of the both due process procedures and even the stay put provision itself. Again, we don't think stay put applies, but stay put expressly recognizes agreement. So agreement is one way to do it. Another way is to engage in an IEP process for Braden If Braden has changed since 2021, which is what the IEP in effect is, then perhaps there could be additional solutions because there would be a new IEP in effect that the parties agreed on that could provide an appropriate placement for Braden. So these are the many solutions the IDEA already offers. Stay put provision is simply not applicable here.
What do you perceive as the then existing current placement?
What is Braden's then current educational placement? It is a residential treatment center. And that has some substance. That's not just a label. That comes from the IEP. The parties have agreed that Braden's sort of least restrictive environment is, quote, a highly structured education and residential environment with one-to-one supervision and a highly structured behavioral intervention program. And throughout this litigation, I think up until, maybe a footnote in Davis's reply brief, the parties have agreed that what this describes is an RTC, a residential facility. And I point the court to complaint paragraph 10, where Davis alleges Braden's IEP recognizes a residential treatment center as his least restrictive environment in which he can be successfully educated, and therefore he would be in a therapeutic environment 24 hours a day, 7 days a week. The district court opinion, page 8, I find that Braden's then current educational placement at the time this litigation ensued include a residential treatment facility with one-on-one support services, significant behavioral intervention, and even Davis's opening brief on page 48.
Okay, so you're agreeing that that's what he needs.
Absolutely.
And that you're looking, but what do we do for interim?
Well, the hearing officer has answered that question. So the interim sort of relief that the hearing officer ordered as part of recognizing that there has been a FAPE denial has been the interim placement at a day school. The district, as my friend acknowledged, has in fact arranged that placement. It's at the Alternative Paths Training School, or APTS. And that day school was made available to Braden consistent with the hearing officer's determination.
Okay, so you're saying that that's available now until you get to a residential facility?
That's right. That's part of the hearing officer's determination.
And that would be attended with all the necessary services as well?
Well, it is a day school.
Right.
But it implements his IEP, and I think I heard my friend acknowledge as well that with respect to the educational services, it does implement the IEP. I think the point of disagreement is the housing.
Is that the only thing that's missing from this interim placement?
I believe so. I want to acknowledge my friend's dissatisfaction with the transportation to APTS. I hope it's sufficient for me to say that the district strongly disagrees with the characterization of the transportation. The district has made available transportation that's compliant with Braden's IEP. So we don't see transportation as having been an obstacle there.
And I thought he was entitled to 24-hour supervision. Am I misremembering that? I thought he was entitled to something.
And that's part of the therapeutic residential environment. That's an RTC. If we could provide Braden with that therapeutic residential placement, that would be an RTC.
But that can't be replicated, the therapeutic part of the residential placement. Like, for example, with a home health aide or something.
That's right. It's a different. It's sort of the distance between an Airbnb and a hospital. The hospital arrangement. Imagine how many things go into sort of this therapeutic residential environment, and that's what's necessary for Braden to access his education. But that's not available right now, and I don't think there's actually that the parties dispute that. Sort of just placing Braden in an apartment or a hotel or a room in a Davis's home satisfies that obligation.
And are you suggesting they turn down the day school option?
I'll let my friend answer that on rebuttal. The day school, to my knowledge, remains ready to serve Braden.
I thought he'd had his first day of banquet. But so it seems to me that everybody agrees about what Braden is entitled to. And I think the issue here is, in my view, a procedural one that perhaps the Davises didn't go about this in procedurally the best way, but both sides agree what he's entitled to. And it bothers me a bit that the district seems to be just saying, well, we're looking, and that's been dragging on for a long time. And it seems that what is being offered in the interim certainly falls short of what Braden is entitled to. So it seems to me that in a preliminary injunction setting, which may be in your future, they might have a quite potentially strong case. And so I would just think that the district would have every incentive to make efforts to reach an agreement with the Davises that goes beyond what's being offered right now.
That's right. And there have been efforts on this front. I mean, I will say the parties engaged in thorough mediation earlier this year. So I think the conversation about sort of can we find a good solution for Braden remains a strong commitment by the district. We're certainly interested in reaching any positive solution. But I think procedurally the state put provision, the district court got that absolutely right. A state put injunction is not the remedy here, and the district court's order should be affirmed. But I guess just to go back on your point about sort of the preliminary injunction and what that might sort of how that might shake out, I will say that, you know, one of the things that I think troubles the district and is part of our sort of alternative argument is that the IDEA does not supply housing. What the IDEA can do is provide education, and then that education has to be proper under the Act. And so any sort of change of placement for Braden would have to actually be an educational placement, somewhere he could access education. If there's no access to, if he can't actually receive education while he's in a placement, then I think that would be a concern of the district, because it wouldn't really be IDEA relief. And I think that sort of goes back to, you know, the way this case was presented to the district court was a case for providing reimbursement for sort of room, board, and supervision, sort of general caretaking. And that's not appropriate relief under the IDEA. That's a lot closer to sort of consequential damages for not having an RTC for Braden. And that's not IDEA relief. But I do think that that would be another way for this court to potentially resolve this case, is to acknowledge that this sort of housing, sort of room, board, and supervision, sort of in the meantime, is not IDEA relief. What it has to be is providing Braden with an education.
I don't think we could make that finding. That would be something the district court would have to find, because we don't know enough about what was happening at this residential alternative to say whether that's education or not.
Certainly. I think I'm previewing in part some of the arguments that the district would be happy to make on remand to the district court. The court has no further questions. The district court's order denying a stay put injunction should be affirmed.
Thank you. I would first like to address the concept of placement. Placement is not simply a physical location. That's well established in the case law. Placement is the entire experience, the overall educational experience that the IEP provides for the student.
Can I ask you a question?
Certainly.
What is it that you would want if you had your druthers and the district were providing some interim services until a residential treatment center could be found? What is it that what would be your wish list of things?
Obviously, if we could not find a residential treatment center, first and foremost, for the district to take the burden off the parents of doing everything for Braden. They are his caregivers, his arrangers.
Could you be more specific? What is it exactly that you want?
Yes, to basically do what the hearing officer ultimately came up with, which is directly provide all components of his IEP, but that would include the components that are to be provided in the residence. The IEP contains provisions. It's not just a place for him to live. He's supposed to be working on his adaptive living skills, his functional skills, his social skills. Those are all to be done in the residence, and none of that is being done now. So we would.
So is it a hotel room, or what is this?
No,
that you're looking
no.
for exactly? Because the RTC is not available. So I'm just trying to understand. I'm hoping the two of you can reach an agreement. So I'm trying to understand like what you're looking for.
The last time this happened, when Braden was discharged from a residential treatment center in 2020, his parents were able to find a house that they rented and staffed there and provided as much of his program there as could be provided. They were able to find a house on a quiet street. It eliminated all those attractions of the hospital near their home. And he lived there for 5 months with aides, with a behavior support program that was developed by a board certified behavior analyst. He received some of the educational components of his IEP, not everything, but he got most of what was in his IEP, and including supportive services. So it could be done. And if, as you said, if we had our druthers, that would be something that we think should be done and could be done. As far as the claim that the district doesn't quote unquote provide housing, they provide housing every time they agree that a residential placement is what the student needs. He is housed. He lives where he receives his education. So all this would be another way of providing that. But in addition to that, as I said, one of the most important things, which continued up until October, a full year, until the APTS made the offer to accept Braden, was to take the burden off his parents. As the circuit said in Booth versus District of Columbia, it is not the parents' job to implement the IEP.
Are you aware of any precedents for the district taking the initiative to put together the house or the apartment, et cetera?
I'm not aware of any precedents for them taking the initiative. The hearing officer did order them analogously to engage a private consultant to help them find the RTC, which to our knowledge did not happen. The district could have.
So it seems that the precedence for what you're asking for is when the parents do the legwork and then the district reimburses. Because what you seem to be asking for is that the district do the legwork, take the burden off the parents, but I don't think they do that.
Well, they are required to provide the educational services.
But practically speaking, it seems that what you're asking for, they tend to reimburse the parents after the parents have done that, and then courts find that that was appropriate.
Well, actually, the hearing officer found that that was not appropriate. In the hearing officer.
No, I'm saying just in precedents where this type of situation has occurred, it's usually a reimbursement of the parents for what they've done.
If the parents undertake a unilateral action and then they are later upheld to have done the right thing, yes.
They get reimbursed.
They get reimbursed. That's the Burlington case and its progeny. But that's not what the Daces were not asking for that, because they were unable to take on the burden here. It was not a question of finding all these providers and simply arranging for them and paying for them. And the one thing the district offered to do was to pay them after the fact, although there have been problems with that. The problem was with delivering the services in the first place. Ms. Davis was very clear in her declarations how difficult it was for her to find everything Braden needed on her own, both because of the payment arrangement and because of Braden's needs made it very difficult to find.
What about the hearing officer's order that they engage an expert to help them?
To our knowledge, that did not happen.
No, but what about that as an option?
We welcomed that. We thought that that was appropriate. Now, that was to help them find a residential treatment center. Well, actually, it was to make recommendations as to the type of residential placement he needed, and then to make recommendations as to where that could be found. It was not specifically to find a residential treatment center. I misspoke. That had that been complied with, perhaps there would have been recommendations. There would have.
So your position is that you're reading the hearing officer's instruction to be addressed to the DC school system. even in this interim period?
Oh, his instruction, in his March determination, he directed the District of Columbia Public Schools to hire this consultant to aid with the search and to make recommendations about Braden's current needs.
So if that hasn't been done, that's something that the preliminary injunction can address.
Yes, and we wished to do so in the case of state, but yes, we could address that. That is not something we are asking this court to deal with directly, but we think it's important for the court to know about the hearing officer's decision. But it is tunnel vision to say that a residential place or that a placement in general is simply the physical location. That has been addressed in this court's precedents in Lunsford, in many other cases. It is the totality of the IEP. It is something more than the physical location, or less than the full physical location, more than just the bundle of services. It is the totality of the educational experience. And that has been found to be appropriate for statehood. I would call to your attention, for example, LJ versus School Board, the 11th Circuit case cited in our briefs, that statehood must produce as closely as possible the overall educational experience enjoyed by the child under the previous IEP. So what we were seeking in statehood was precisely that, to give Braden the educational experience he is supposed to receive under his agreed IEP. And if a residential treatment center was not available, there were ways to come closer to his IEP than the district offered, and that the district court therefore allowed them to continue it with the, as I said, the placing close to the full burden on the parents, sending him home, removing him from any contact with his non-disabled peers, home being a more restrictive environment than even a residential treatment center where he at least would interact with peers to some degree. The uncertainty of the ability to fulfill even what the interim services letters called for, all of those things were implicated by the district's failure to find a new residential treatment center. And those things should have been addressed in the preliminary injunction, even if a
anything new that you want to argue on reply? Because we've heard these arguments before from you.
I would simply reiterate, there was a question.
No, reiteration is not a response.
No,
Don't we fully have your argument?
I would just like to respond to a few things that the district said. For example, the Alternative Paths Training School, while it is prepared to offer the day program, Braden will continue not to receive any of the after-school services. And therefore, while it would be better than sitting at home, it is not a substitute, it would be an interim. I would also like to address the compensatory education question. Compensatory education is not the appropriate remedy for a denial of statehood. Compensatory education is something that is done when there's been a failure to provide a free, appropriate public education. But the duty is to provide the free, appropriate public education from the outset. And any delay in providing the education the student needs is deemed to be irreparable harm, which is why a statehood injunction does not require proof of that harm. So while compensatory education may unfortunately be the remedy that's left to Braden for the time that has already passed, it is not an adequate remedy. It would be like saying we don't have to repair the sidewalks too quickly because if somebody slips and falls and breaks a leg, we'll pay their medical expenses. The goal is not to have the slip and fall and break the leg in the first place. The goal is for Braden to have his uninterrupted services.
I know,
And-
but your logic and example don't work. Because when there is a sidewalk problem, the district fences it off for a while, hires a contractor, and then somebody comes to repave. So you don't have the pavement restored immediately. Anything new?
Hopefully the court understands our position.
Thank you.
Thank you.
Thank you very much. Okay, the case is submitted.
Case number 22-1096. Xwell Energy MALP and Xwell Energy LLC petitioners versus Federal Energy Regulatory Commission. Mr. Siegel for the petitioners, Mr. Glover for the respondent, Mr. Mays for the intervener.
You may proceed.
Good morning, Your Honors, and may it please the court. Peter Siegel for the petitioners. I'd like to reserve 3 minutes for rebuttal. The orders on review are arbitrary and capricious on both grounds the briefing addresses. Starting with the remedy issue, there are 3 reasons for vacator here. First, at JA 251 to 253, the Commission committed legal error in concluding that, as a matter of law, it lacked discretion to award any remedy other than the one that would be appropriate for a 206 violation itself. What my clients are asking for isn't a remedy for a Section 206 violation, it's a remedy for a filed rate violation. And if you look at page 47 of the Commission's brief, they say, well, the reason we looked at Section 206 and attempted to do the Section 206 calculation is that this is a Section 206 case with no unique or novel aspects. But the filed rate violation here is a quintessentially unique and novel aspect that broadened the Commission's discretion to look beyond just the comparison of 2 rates and obviated the necessity to calculate what would have been charged under the pre-2017 rate. So after finding that it couldn't calculate what would have been charged under the pre-2017 rate, which is a finding that we disagree with, and I'll explain why in a moment, the Commission had certainly at least the entitlement and the discretion to, and in our view, the obligation to look beyond that and attempt to find another remedy. But it didn't look beyond that. It just said, okay, we can't do the Section 206 violation. Our hands are tied. This is a filed rate violation and we can't remedy it. And that was erroneous as a matter of law. Second, even assuming the Commission could look only to the pre-2017 rate for the remedy, it acted arbitrarily and capriciously in concluding that it couldn't calculate the amounts that should have been paid under the pre-2017 rate. And there are 3 reasons for that. The first one is that the Commission asked PJM, not the independent market monitor, whether the software had been updated. But under PJM's FERC-approved tariff, it's the responsibility of the market monitor, not of PJM, to make those calculations and maintain that software. So the fact that PJM couldn't do it is really beside the point. Or the fact that PJM claims it couldn't do it is beside the point. The question is whether the independent market monitor could have done it. And FERC didn't even ask.
Before you even get to that, don't you have an issue about the rate being the default because of the timing issue?
I'm sorry, Your Honor, being the default because of the timing issue?
Yeah, like in other words, the rate gets stated because the preliminary or interim rate, it ends up being the rate because it was not approved by FERC timely.
So we certainly, it's undisputed that there was an egregious filed rate violation here. And that filed rate violation arises because PJM, without any approval from the commission in advance, charges a rate that is not the filed rate. And the commission won't dispute that when they stand up, and the IMM won't dispute that when they stand up. There was a filed rate violation in this case. There was no entitlement for PJM to go ahead and charge the unapproved interim rate when it didn't have FERC's approval to go ahead and do so.
But can you explain though why Towns of Concord doesn't govern this? Like they have discretion not to order a refund. And I'm trying to understand your argument that you're saying that they didn't understand they have discretion.
Your Honor, the first argument we made in the brief was that Towns of Concord doesn't govern here. And we will readily agree with FERC that there is discretion to fashion a remedy in the context of a filed rate violation.
Including no remedy if they choose to do that.
So on some facts, the commission has discretion not to provide a remedy. That's what Towns of Concord stands for. Towns of Concord was the case that involved an accidental passed-on overcharge of $30,000 over 15 years. And the regulated entity essentially got a bill, passed it on to ratepayers, and didn't, according to the case, didn't really even look at the bill. They just sort of passed it on. And it turned out that at some point when they were passing those bills on, the components of the bill changed. Something was added that they weren't allowed to pass on.
I understand.
And the commission says,
but similar to Towns of Concord, you could only prevail if they are required to give refunds. And I don't see that.
No, Your Honor. Even if you assume that there's discretion not to provide a refund in general, our argument is that the bases that the commission invoked for declining to provide a refund here are arbitrary and capricious. And the first of those bases is the one that I've been discussing, which is that. So
an abuse of discretion. They have discretion to decide what the refunds are, and you're saying they abuse their discretion?
They acted arbitrarily and capriciously in invoking improper grounds and irrational grounds for declining to provide a refund. And the first of those is the error of law, that they looked only at the possible Section 206 remedy calculation and didn't look at other possibilities, such as refunding all amounts paid.
Well, they looked at that because that's what you proposed, right? So, but they chose something different.
No, we did propose it, Your Honor, but what they said was the remedy has to be either the Section 206 remedy or no remedy at all. And we can't calculate the Section 206 remedy, so we can't provide anything.
So they were at liberty to reject your calculation, but you're saying that they erred by not stating that they were doing so.
Well, they provided no reason other than an apparent belief. If you look at JA 253, they say the appropriate remedial calculation has to measure the difference between the pre-2017 rate and the unapproved interim rate. I'm paraphrasing from JA 253.
Okay, I'm looking at it. Which paragraph are you?
So that's paragraph 18. We continue to find that the appropriate refund calculation would have required a comparison of the proposed 2017 forfeiture rule with the pre-2017 FDR.
But they said that's the appropriate refund calculation. Isn't that them saying that they think it would be appropriate, that it must be done this way, which is different from we have no choice but to do it this way?
They offer no reasoning other than, and if you look at page 47 of their brief, what they say is the reason for that is that this is an ordinary Section 206 case with no unique aspects. But it's undisputed this isn't an ordinary Section 206 case. This is a Section 206 case with a filed rate violation on top of it. As Judge Shouts was mentioning, under an ordinary Section 206 case, what they would have done would have been to continue charging the pre-2017 rate until a new just and reasonable rate was approved. And then the commission would have looked at the difference between the new just and reasonable rate and the pre-2017 rate, and it would have had discretion. You know, there are a lot of DC Circuit cases about the discretion that it has in the context of Section 206. Provide a refund, it cannot provide a refund. FERC has a lot of policies about when it does so and when it doesn't do so. But in this case, what FERC concluded was we can't do that calculation because essentially there was a filed rate violation. We don't know what would have been paid if PJM had followed the law and continued to charge the pre-2017 rate. That's a mystery. And the reason it's a mystery is because they violated the filed rate doctrine and didn't do what Section 206 required them to do, which was to continue to charge that rate.
So am I understanding your argument to be that they would have had discretion to say that the correct calculation is the one that finds the difference between the pre-2017 rate and the 2017 rate, et cetera. But because they did not state we're exercising our discretion to do that, and did not explicitly state and we're rejecting the just refund everything approach that you proposed, that they erred. It's really a matter of the way they phrased it, is my understanding of what you're saying.
No, Your Honor, I disagree with that.
But you're saying that they would have had discretion to do that, but you're just saying they didn't exercise their discretion because of the way they phrased it in paragraph 18?
No, they didn't ultimately do that, right? They would have had discretion to provide a remedy based on that. But what they found was we can't provide a remedy based on that first calculation. That's our option A. And we can't do it because we don't know what would have been charged under the pre-2017.
But they're not saying we can't, they're saying the appropriate calculation is this comparison of proposed 2017 with pre-20. They're saying that it's the appropriate way, and since we can't do it, we're not going to provide a refund. But you're saying that because of the way they phrased this, because they used the word required, they didn't recognize they had discretion.
Well, and they provide no reason, to the extent you want to look at the phrase, the appropriate refund calculation. I think your point is maybe they were exercising discretion because they say the appropriate refund calculation would have been this.
Yes.
The question is why? It's utterly arbitrary that they determined that that's the only appropriate refund calculation. Under Section 309 of the Federal Power Act, they have broad remedial discretion to remedy violations of this core doctrine. And
But again, they have discretion to reject your proposal, and you're just saying they didn't explicitly say, and we reject that.
no, they didn't provide any reason for determining that the appropriate refund calculation is this measure instead of a different measure. We propose other measures as well. And under APA review, they can't simply say those don't work. They have to say why those don't work.
Can I ask you a different question? Can you explain the leverage point? I'm having a little trouble understanding
Yes.
what that issue is and why the response was relatively inadequate.
Sure. So this goes to the 2021 rate. And I do have other points that I'd like to return to if time permits on the remedial issue. But on the leverage issue, and on the 2021 rate, we have 2 points. We have the portfolio issue and the leverage issue. And the basic idea of the leverage issue is that if you don't stand to make more money from supposed FTR manipulation, then you would lose in the process of engaging in virtual trades to manipulate the FTRs.
Why is that leverage?
So the
When I think
idea
of leverage, I'm thinking you're taking on debt to buy securities. Bothering me.
The idea is you've got more weight on, in order to make money through your FTRs, you have to have more weight on your FTR position than on your virtual trade position. And if you have more on your virtual trade position, you're not going to sacrifice the virtual trade position to make money on the FTR position. It's the same concept as, in a chess match, you might sacrifice a pawn to save your queen. You're not going to sacrifice a queen to save your pawn. And the idea is that in the context, and really the first thing I would say is in the orders on review, if you can't parse what the leverage position is and why they rejected it, that's a reason for vacator and reversal. The commission is required to explain the justification for its action. And if sitting here today, we can't determine the justification for its action, then that's a ground for vacator. Of course, the leverage issue, as we point out in the brief, it is impossible to determine why they rejected it because they repeatedly conflated it with the portfolio argument, which is a different argument from the leverage argument. And it seems that they rejected the portfolio argument irrationally on the ground that they had already rejected the leverage argument. And then when we talk about the leverage argument, they just go back to the grounds on which they rejected the portfolio.
Are you saying then that if there isn't leverage, then there isn't market manipulation? Because in order to, of course, the whole purpose of manipulation is to make a profit from it. So is this sort of by definition what the manipulation would be, that the FTR, that you have more weight in FTR so that when you change your virtual portfolio, you're making a profit on the FTR? I'm trying to understand because they say, is it necessary? And I'm trying to understand, is it necessary that for there to be leverage in order for there to be manipulation?
Yeah, so short answer, yes. And I actually think, if you'll indulge me, it's easier to explain through the portfolio concept,
Okay.
which is very similar to the leverage
Okay.
concept, and I'll explain how they're slightly different. But they're the same sort of general, they're related general. So the portfolio idea is that if you stand to make money on an FTR, you know, a $5 FTR, say, going in one direction, right? But you have a $100 FTR going in the other direction.
Mhm.
And then your virtual trades, they would be promising and helpful for the $5 FTR going in the first direction. But they would lead you to lose money on the $100 FTR going in the other direction. And I should make clear this is a gross oversimplification.
Yes, understood.
But the commission said, well, you might have an incentive still to manipulate for the benefit of that $5 FTR. So we don't even have to look at whether, in fact, you would be losing $100 on some other FTR portfolio. And we said that doesn't make any sense. Nobody would engage in that conduct as FTR manipulation. You might want to make virtual trades that would have that effect, but you'd be making them for another reason. For instance, you think you're going to make a profit on the virtual trades. You're not doing it to manipulate FTRs because you're going to lose $95 on FTR. And you know that in advance. And so what the commission and the IMM have both said is, well, we don't want this to depend on whether you're going to make a profit. But our point isn't look at it from after the fact, and if you don't make a profit, then you get off scot-free. It's that nobody would engage in the conduct as FTR manipulation in the first place because they know I'm going to lose money on my FTRs if I do that. So it's not FTR manipulation. Are there further questions on the...
How does that explain leverage?
I'm sorry.
How does
And so the
that explain
leverage concept, I apologize for now returning to the leverage concept. But the basic idea of this portfolio concept is that the trades are going to cause you to lose more money on your FTRs than you would overall than you would gain on the single FTR that you supposedly manipulated. So you would never manipulate that FTR. The leverage concept is you're going to lose more money on these virtual trades than you would stand to gain on the supposed FTR manipulation. So you're not going to engage in that conduct because, again, you know in advance that if you don't stand to gain more from the FTRs than you're going to lose with respect to your virtual position, you're just not going to do it. It's not profitable. And you know in advance that it's not profitable. So you're not going to engage in supposed manipulation that's a money-losing proposition from the outset. And there's been as we discussed, there's no response from Ferc on the virtual position.
So was your proposal that before there could be a forfeiture, they have to calculate the leverage basically to make sure that they would have profited from this?
Yes, they have to take account of leverage positions, and in the portfolio argument that they have to look at the entire portfolio. They can't zero in just the FTR at issue. They have to look at whether you would have stood to make money.
That's the portfolio one. I'm talking about leverage. So what was your proposal on what they should do about the leverage issue?
So I don't know that it got more granular than essentially take account of leverage. Look at whether a particular market participant actually stands to gain more from the FTR than they would lose in, quote, manipulating the FTR. And if they don't, then it can't be FTR manipulation. Because
I see. So the idea is it would not, it's necessary to manipulation because they're not making money otherwise. So there would be no incentive to do this as a manipulation.
right, exactly.
So your point would be that it is necessary, that leverage is a necessary component of manipulation in this context.
Yes, exactly.
And so when the commission said it is not necessary, that was arbitrary.
Yeah, we disagree with that, and I would love to disagree with their reasoning for that, except as we sit here, we have no idea what it was.
What's your remedy for them not sufficiently explaining to remand for the explanation?
So on the virtual issue, I think only a remand would be appropriate. The record just doesn't demonstrate what the commission's rationale was at all. On the portfolio issue,
On the leverage issue.
on the leverage issue, I think remand is appropriate. I don't think.
Remand without vacator.
Oh, no, I'm sorry, Your Honor. Vacate and remand. We have no basis for concluding why they reached the decision they did. I think vacator is appropriate in those circumstances in addition to.
Will it create confusion in the market if we vacate? If we could remand and say, explain yourself better and not vacate, but would it create confusion in the market if we were to vacate?
So I want to address that. I would first say the remand without vacator approach is usually adopted when there's some reason to think that the agency would reach the same result on a remand. And again, here, we have nothing from the agency about why they reached the result. And
we need more explanation.
Well, it's true that we need more explanation, but also there's no reason to think that if the commission were actually put to providing that explanation, they would reach the same result, because in our view, as we've discussed, it doesn't make sense. And it's the same in the context of the portfolio issue, except that there they've actually provided their rationale, and it doesn't make sense. The rationale is essentially, you might do this because you'd like to have $5 in your left pocket, even if it's going to cost you $100 out of your right pocket. And that's, they said you'll manipulate one FTR, even if you're going to lose money overall. That doesn't make any sense. There's no reason to think that if they were required to come up with an explanation that did make sense, they would reach the same result. And in our view, they couldn't possibly reach the same result. So that's a vacator issue. And I think both of them are vacator and remand issues at worst. In the context of the portfolio approach, I think it would be appropriate to reverse entirely.
But didn't the commission explain the complexity involved in ordering refunds beyond the points you're making, and therefore it didn't have to reach those points?
I don't think so, Your Honor. Everything that they said was in the context of kind of bolstering their initial conclusion that they wouldn't provide refunds under the Section 206 calculation.
No, they said, look, they balanced and they addressed your issues on remand, and they didn't find, after they modified their original order in some respects, that your arguments should prevail over the balance that the agency had thought should control here.
Well, so Your Honor, that's their bottom line conclusion, but it embeds the bevy of errors that we've discussed in the briefs. For instance, it rests on the conclusion that PJM can't calculate the refund amounts because it's failed to maintain the software to do so. But failing to maintain the software is an independent filed rate violation. The question isn't whether PJM can refund the amounts, but instead whether can perform the calculation, but instead whether the IMM, which the tariff requires to be the one that performs the calculation, can do it. And the
yes, but the issue is if the necessary data for the calculation no longer exists, that's a different issue. It's not that somebody else can recreate.
So, Your Honor, I think that question goes to this reliance idea, which is that PJM said that, even if we had properly maintained the software as the filed rate doctrine required us to do, you still couldn't provide a remedy here because nobody knows what market participants would have done if they charged.
Because market participants changed, the markets changed. I mean, we don't have a static situation here that a number of your arguments are premised on. And your recreation argument, it seems to me the commission could probably say, balancing what's at stake here, we exercise our discretion not to order remedies.
Well, Your Honor, those aren't magic words that they can say at the end of an irrational analysis.
Yes, but they can do that at the conclusion of an analysis that is different than yours. In other words, they don't have to accept your approach willy-nilly. They can explain why they're not going that way and come out with a conclusion that differs.
Yes, Your Honor, I agree with that. But I would say that at every step of that analysis, they in fact made errors that made the bottom line result.
Well, you're saying that a filed rate violation is different than the normal 206 violation. Why is it different? I mean, it's different in the sense in some instances, it's a more egregious violation, all right? As opposed to an error in calculation. But that doesn't make the 206 proceeding inapplicable, which seems to be the premise of your arguments here.
Well, actually, Your Honor, in one very real sense, Section 206 is inapplicable, which is that in the context of the Section 206 replacement rate proceeding, the authority to provide a remedy arises under Section 206, which very precisely sets out essentially a math problem that the commission can decide to do or not do subject to its discretion.
It's not a math problem. That's the whole point, isn't it? That Congress understood these were difficult balancing situations. And it's not just adding up one column of figures versus adding up another column of figures. These are expert judgments, and Congress has delegated that expertise to these expert commissioners. Not that it's a mathematical calculation that sort of anybody could do.
Well, Your Honor, I agree with you in the context of Section 309 and remedying filed rate violation. In the context of Section 206, it is a simple math problem. And the problem here is that what the commission did was it tried to do the Section 206 math problem, found it was unable to do it precisely because PJM had committed a filed rate violation and made one of the variables for that math problem more difficult.
That is not what the commission said.
Your Honor, the principal basis for the commission's conclusion was the declaration of Brian Chmielewski from PJM, who said, we don't upkeep the software. We haven't maintained the software to calculate what the charges would have been under the filed rate. And even if we had, you can't know what market participants would have done if we had adhered to the filed rate doctrine and charged the filed rate. There was market participants' reliance on our violation of law. Obviously, I'm paraphrasing that, but that's the substance of what he said. We didn't follow the filed rate doctrine. We didn't charge the filed rate, and you can't know what anybody would have done if we had, so you can't provide a remedy. And the commission bought that reasoning without any recognition that that makes the filed rate doctrine, which according to the Supreme Court's decision in Maisland, is utterly central to regulatory regimes that require just and reasonable
And the
rates.
commission has reaffirmed that time and time again, but it doesn't necessarily mean that a violation of the filed rate doctrine obligates it to order refunds. And that's the point, it seems to me, you don't want to acknowledge in our cases. And indeed, the Supreme Court have acknowledged that discretion lies with the commission.
No, Your Honor, I will readily acknowledge the discretion lies with the commission. That's Townsend Concourse.
No, you really don't. You're saying that 206 is mathematical, and that's the end of it, basically. And there's discretion, but it's very confined because this is a filed rate doctrine. And I understand your argument, and the commission could have adopted it, but it did not. And it explained in the language of our opinions, the path of the commission can be determined and reasonably understood.
So, Your Honor, I think as I've stood here today, I've actually been arguing that it was the commission that viewed its discretion as unduly constrained by Section 206, when in fact the commission's remedial discretion was broader than just the 206 remedy. And what the commission should have done was look to other possible remedies in recognition of the fact that the filed rate doctrine is utterly central to this regulatory regime. And so instead of just looking to the Section 206 remedy and finding, well, the filed rate violation makes it impossible for us to provide this 206 remedy, ergo we can't do anything.
So if I may, I'm looking at what the commission did right now, paragraph 16. And I think it's important to note that the commission directed PJM to include information on, quote, the method by which PJM would calculate refunds and surcharges based on the prior rate on file. So that was the task that they assigned. They wanted the refunds to be based on the prior rate on file, which is within their discretion to determine that that's the appropriate refund. And then it says XO Energy posits that PJM should refund all FTR forfeitures dating back January 19th, 2017. So clearly they considered your proposal.
And their answer to that is
They disagree. They want to do it based on the prior rate. They're entitled to do that. They have discretion.
So, Your Honor, if they had said only that under the APA, that would be a ground for vacator and remand. We don't want to do it. It's not a valid exercise of agency discretion.
That is not what they said, counsel. I mean, with all due respect, you may disagree with its reasoning, but what Judge Pan just quoted from the rehearing order is not what the commission said.
So, right, and that was going to be the second part of my answer. They, in fact, did not say only that. What they said was, in the context of just essentially what calculation can we do? What are we empowered to look at as a possible remedy here, right? They said, in the context of rejecting our argument that they should just refund everything.
But before your argument, they'd already decided they wanted it calculated based on the prior rate on file. That was the instruction in the prior order.
So, and then they concluded that
And then you said that why don't you just give us all the refunds?
Right.
And they said we disagree. And they said it should be based on the prior rate on file. And then they said that's the appropriate calculation.
Right, because
so they're entitled to do that.
Because the pre-2017 rate was the effective rate on file.
Right.
In our view, and I recognize
I
I'm way over
understand your
time.
view.
Our
But
view is,
that's not what they chose to do.
right. Our view is that that response was a non sequitur. That response, if this were straightforward
I
to a
think we
sixth
understand your
proceeding.
view.
Thank you.
Thank you.
Thank you.
May it please the court, I'm Matthew Glover and I represent the Federal Energy Regulatory Commission. I realize this is factually and legally complicated, so I want to start with a couple points on the remedy that I think will clarify. First of all, I think my friend on the other side made an important concession that we do have discretion even in filed rate cases. That was clear from Townsend Concord. It was clear from a few of the other cases we cited as well. The Keyspan Ravenswood, this court reversed us and said there was a filed rate violation. Go back and decide if you want to remedy that. In Consolidated Edison in 2003, we cited both of these. You did the same. You reversed us, said there was a filed rate violation. We came back in 2007 and said we've decided not to remedy that. You said we rebalance the equity. So that's an important concession because they are tied to the arguments they made on rehearing. Their principal argument on rehearing was that we lacked discretion. But stepping into how we exercised our, I want to note one more case on the filed rate. Recently in 2018, in an unpublished decision in Ameren Services Co. versus Ferc, that's number 131138 at 739 Fed Appendix 646. The court again was confronted with a filed rate violation that we found equitably there was no remedy. And among the factors that were considered, there was reliance, was the time, expense, and difficulty with developing software. It was a different regional transmission organization called MISO or Mid-Continent. They hadn't kept up their software. We said that was an issue. So I think that case looks at a lot of the same things, but there's a little bit of confusion here on the remedy. My friend keeps saying we constrain ourselves to Section 206. That's not true. Actually, the normal remedy if I can step back and look at Townsend Concord, it's more of what I would call classic filed rate case where you were charging a cost-based rate. You weren't supposed to include the spent fuel cost, but you did. And so you were supposed to charge X, but actually you charged X plus $36,000. The remedy in a filed rate case is the remedy between what you charged and what the rate on file was. And that's why, Judge Pan, I think it was paragraph 16 at JA 251 in the hearing where you went to, we were in those paragraphs. Our heading there is the pre-2017 rate was the rate on file, right? They had made arguments both on appeal and below that there was no forfeiture rate because that rate was found unlawful. That's where the 206 provision comes in. 206 structurally, when we declare at step 1 a rate is unjust and unreasonable, we have to go forward with that step 2 process. We cited Era Energy for discussing, which I think is a 2017 case, for discussing why. There's actually 2 cases from the circuit that more clearly state. One of them we cited, but not for this proposition. It's the recent MISO transmission owners versus Ferc 45F 4th 248. We cited it for a different proposition, but at page 253 there, the court notes that after the step 1 provision, quote, until FERC sets a new rate in a 206 proceeding, customers continue to pay the challenged rate. So that's why it remains the rate on file and you were supposed to continue paying. Now, if we were going to remedy this as a 206 violation, my friend did point out that 206 has some provisions. One of them is there's a 15-month limit on refunds. When you refund a 206 violation, what you do is you say, you were charging an unlawful rate. You keep charging that unlawful rate, and when we figure out what the lawful rate is, you refund the difference between the lawful rate and the unlawful. So if the refund calculation for sort of a 206, if they had kept charging the pre-2017 rate and never commit the foul rate violation, we would still have discretion on whether we wanted to refund. We'd be limited in a number of months, but the refund calculation would actually be running the new rule that we approved in the compliance order. What are the refunds? What were the forfeitures under that versus the pre-2017? And that's not what we were doing here. Here we were looking at the rate on file, which is the pre-2017 rule versus what you charged. That's how you remedy a file rate violation. That's what we were trying to do. We looked at factors. We asked PJM to provide us information, and we considered what we think are appropriate factors. They're factors that this court in Ameren has looked at. I would note Towns of Concord noted the difficulty and the time and expense involved in trying to reconstruct the rates at issue there. So I think each of these factors have been applied by the commission and accepted by this court in various cases on those. So I think that's the key point I would make there. I would also cite the 2014 Louisiana Public Service Commission we cited in our brief. It also went through and included, I think, every one of these factors.
Could you address the leverage issue?
Yeah, I'll take a quick print if you don't. So I didn't really think about it this way till I read their reply brief at 12 and then again at 14. They describe both leverage and portfolio involving the intent to manipulate and needing to have the intent to manipulate. And so if you look at the compliance order at paragraph 44, which is JA 204, we said there that we had previously rejected arguments about scienter or intent to manipulate in the 2017 order. No one sought rehearing of that. And so, as we were narrowing the proceeding, right, it starts with a 2014 proceeding where they're adding these up to congestion trends, and we narrowed it in 2017 and said, PJM, you need to catch less hedging activity. You need to sort of narrow this rule. Here's what you need to do. In that order, we rejected scienter or intent. And so insofar as they're arguing it's a necessary component of the final rule because you can't capture intent or scienter without that, which I think is how they framed it in their reply brief. We rejected that in 2017, and in 2021, we said that that was an inappropriate collateral or an inappropriate rehearing request or collateral attack of the earlier order. And I guess this goes to some of the market monitor's points, but on the sort of inappropriate rehearing or collateral attack, again, I would cite to a very recent opinion of the court. It's another Louisiana Public Service Commission case. There's a lot of them, but this is the 2022 case number 20-1315. It's unpublished. It's from last year. It's 2022 Westlaw 801353. There, Louisiana had a series of these cases about specific remedy. We had decided, I think it was in the year 2015, that they weren't going to get certain types of refunds. They didn't seek rehearing of that. At the end of the case, they then sought to challenge those refunds. We said that's a collateral attack on our earlier order. You needed to seek rehearing. They responded, well, that earlier order wouldn't have been final, so we couldn't have gone to the Court of Appeals. And this court said FERC was within its discretion to treat its proceedings that way, and it analogized to your own law of the case precedent. That even though Louisiana was claiming it wasn't final and they couldn't have got to the DC Circuit in 2015, our rule was you needed to challenge that on a rehearing, and we later treated it as, sorry, Your Honor.
So can I ask, I know that you're framing this as scienter, but my understanding of their argument, and I'd appreciate your guidance on this. Beyond my depth a little bit. Their argument, I think, is that there's no manipulation unless there is leverage, because otherwise it's just a series of transactions that happens to have a certain effect. But unless they're profiting, that's not manipulation.
So that's part of the structure of this. This is an ex ante rule that is designed to catch when virtual transactions are having an impact that raises the value of your financial transmission rights, being cross-product manipulation. Again, parties argued throughout that you need to show a profit or you need to show sort of intent or other things.
No, but I'm saying, is profit different from intent?
Well, yes, to an extent, but one of the things, and again, I don't mean to get too technical, Your Honor, but you have to understand that these are paid out and they're based on different things. So an FTR is going to be on a path from point A to point B. And if there's congestion places along that path, you're going to get paid for those congestion charges. One of the things we criticized PJM about and asked them to revise from the original rule was these INCs, and I think it's incremental bids and decremental, I'm forgetting the term, but the two initial types of virtual transactions where you virtually offer to buy or sell at one specific place, you're going to make money on that based on what the dollar value and sort of whether if you're selling in the day ahead and buying in the real time, if you sold for higher in the day ahead than you bought for the real time, you made money. One of the problems with the original rule, and it had this worst case scenarios thing, was you could make a bid very far away from your FTR or your financial right, and it would still like increase. And this was a problem with the 1 cent test. It would still increase the FTR in some way. And so you'd forfeit. And we said that's too tangential. And so this idea of leverage or profiting, the problem is you don't know whether you're going to make money. You're speculating on what you think the price tomorrow versus today is at this one location. And that's going to have an effect on your FTR, but you don't know, like I'm over my time. Your profit is going to be based on what happens as to that location, not what happens everywhere along the path of the FTR. And so you're sort of bidding and speculating in two different markets. And what we're concerned with is these virtual transactions can create congestion. Congestion is then paid by the transmission ratepayers. And that congestion, you shouldn't be benefiting when you created that congestion with your FTR, because then you're using your virtual transactions and you are benefiting from it. Again, you might be making a really big bet on what the price is going to be like in Richmond tomorrow for power, but your FTR may run from DC to Baltimore, but that Richmond purchase, because they have to model this entire grid with where all of the power is moving, et cetera. That Richmond purchase is going to affect where they're modeling the grid and where the power is moving.
So what is the difference between? So the premise of this is if you manipulate things in your virtual portfolio that affects the price of the FTR, you would only forfeit if you're profiting on the FTR. So what's the difference between leverage and just a violation where you're profiting on the FTR?
So I think that there's 2 points. One is the manipulation is that your virtual transactions, which is one market, you can profit or lose in those, are benefiting your other set of transactions. And if I can give an example for where the rule is technically under-inclusive and how we don't go after intent. If you had a situation where you engage in a bunch of virtual transactions to raise the value of your FTR, you were meaning to cross-product manipulate, and you raised the value of your FTR because you created congestion between DC and Baltimore. Again, I'm simplifying, like there's only 2 transmission lines or something. And so congestion ended up being $100. Your FTR's value was going to be $100. You got $100 for congestion. But it's the day ahead market for tomorrow. Overnight, an act of God knocks out the main transmission line there, such that there's massive real-time congestion between DC and Baltimore. And there's a whole other case about this. PJM has a $2,000 limit, so the congestion price can't go above that, but it causes the congestion price to go to $2,000. You don't have to forfeit your FTR profits because the last provision of the forfeiture rule is you only forfeit when the day ahead market had greater convergence or greater congestion than in the real-time market. And that's because the idea of virtual trading is that it will provide not just liquidity, but efficiency, and that the day ahead market will look more like the real-time market because of virtual trading. And so in that case, you intended to manipulate, you did manipulate, you got money off of your FTR, but because there was market convergence, you didn't get penalized. Now, I believe it was Exxon or someone earlier on in the 2017 proceeding, there's a lot of orders and a lot of descriptions, argued that, well, wait, sometimes you can increase convergence and you're still manipulating. And it was one of the reasons we added the rule to what are called counterflow FTRs. Again, I apologize for getting really technical. But we said, we're still only going to, make you forfeit your profit when at the end result was greater congestion the day ahead than in the real-time market. Again, because the virtual transactions that created that congestion in the day ahead market, someone's paying that congestion. Like that's actually impacting the system. And that's where when we talk about portfolios, we're worried about your full portfolio of virtual transactions because we're worried about how you actually caused or didn't cause congestion. Sorry, I know I went very...
But so then if your virtual portfolio, you lose money on it and you gain money on your FTR, like why isn't that an appropriate comparison to make, which I take it is the leverage point?
Again, the point being, we don't want virtual because people know that you're buying these at different times. You know that you have an FTR here. We don't want you engaging in virtual transactions. For example, speculating really wildly that, gee, we really think the price enrichment is going to go wild. And we'll make a lot of money. But if we don't, we have this backup DC to Baltimore FTR that will also be helped by this. So, in the event, if we speculate correctly, the FTR doesn't make us money, but we make a bunch of money in the virtual transactions. But if we speculate incorrectly, the FTR is going to make us money. You've still engaged in a virtual transaction that is going to raise the value of your FTR and that's going to cause congestion, right? So we weren't looking at, gee, should you be kind of speculating wildly? It's, are you engaging in and again, if it were only up to congestion transactions, which is the type we added, it'd be a little easier to see because those have a start and end point. And so it's a little easier to see where those are going to have an impact. But because virtual bids can be at a location that, impacts your FTR path, but it's not the entirety of your FTR path, or it could be where the constraint is somewhere else on that path, the constraint being the congestion. It may not be the whole path. It may just be a limited piece of the path. We didn't think for an ex-ante rule, right? We wanted an ex-ante rule. Some regional transmission organizations kind of after the fact police this, but we found it acceptable for PJM in 2001 and since to have an ex-ante rule that tells you when your virtual transactions will be considered cross-product manipulation because they are impacting the value of your FTRs. You're only going to forfeit when you profit because we don't think you should forfeit when you didn't profit on the FTR. And again, that's a lot of narrowing. And if I can make one point about hedging, FTRs were designed as a hedge for load-serving entities like, I think, Exelon or Constellation in Maryland or Dominion in Virginia that serve customers, right? They have to purchase what's called firm transmission because they don't want to be curtailed when they're buying power. And so when they purchase this firm transmission, they're given these things, auction revenue, right? Anyways, they can convert these into firm transmission rights. The idea being that if you're a Virginia customer like I am, and there's congestion getting the power to Virginia, Dominion isn't going to keep changing the price on me and charging me for that. They're going to hold an FTR that will allow them to get that congestion money back. So the FTRs are designed for those entities to hedge. And that's the kind of legitimate hedging that we're concerned with.
But with respect to the leveraging, in the 2017 order, there was a statement about leveraging may play a part in the cross-product manipulation, but it's not a necessary condition. So where do you take that position now?
So I think, sorry, I didn't mean to talk over.
Yeah, your position.
That goes to the structural point that this is an ex-ante rule, right? And so in my example, you leveraging that you're planning to make a lot of money on this, FTR by making these small bets in the virtual transactions or making specific bets that your intent, again, like it may play a part that you have, used your virtual transactions to make money. We didn't think that when we're establishing an ex-ante rule that will just let you know when you engage in this conduct, you will forfeit. We didn't think it was necessary to consider that. We thought you could have a just and reasonable bright line.
What can a
bright line isn't really, sorry.
What can a non-leveraged transaction be manipulative?
Again, I think the problem is that you don't, the way that the FTR is paying is different than the way that the individual virtual transaction is paying. And so you could be making a very large virtual transaction, expecting the price to be exactly the same today and tomorrow so that it'll net you nothing. But you want it to raise the value of your FTR. If you want your FTR to go up $100, you bet $1,000 over here, but your intent was to win on the FTR because you think that 1,000 here is not, you think there's going to be no congestion, no nothing. So you're betting that, assuming that tomorrow the price will be the same, right? You were intending to manipulate your FTR. You've made this bet with the intent to manipulate your FTR. But it turns out that in the virtual market, something happened that caused your bet to be a losing one. And so you made $100 on the FTR like you intended to. You actually, rather than selling for 1,000 today and buying for 1,000 tomorrow, something happened in that location such that the price, was different and you lost money. You intended to make money on your FTR by betting on your virtual transaction, but you didn't. And again, that's because the FTR can make money. The FTR can make money from the entirety of its path, like congestion on different points along its path. The virtual, in terms of the increment and decrement, is a specific location. And that's one of the actual narrowing provisions in the final rule, is that we didn't want to look at the entire FTR path. We wanted to look at where your virtual transaction caused, like which constraint. There could be multiple congestion points on an FTR path. And if the one that led to their increase in value was not the one your virtual transaction had any impact on, you don't need to forfeit. Under the old rule, you actually would have forfeited.
I think Judge Rogers might have had a question.
Oh, sorry, Judge Rogers.
No, I thought the explanation was helpful.
I know I'm well over. If I could cite a couple.
I just want to note, I think that your opposing counsel made the point that if we can't understand what you did, then we should vacate because you haven't explained it adequately and haven't addressed it meaningfully. And through all this argument, I'm sort of starting to understand, but it seems that as an initial matter, like you are obligated to address their concerns meaningfully. And if we're having so much trouble understanding what you did, why isn't this a remand so that you can explain it?
So I think part of that goes to, again, the structure of this proceeding, things like the intent point. Early on in the proceeding, in the 2017 order, we addressed a lot of these arguments. And in the 2021 order, we addressed some more. And, by the time we got to the 2022 or the compliance order, right, we were directing them to make specific changes. And this is actually exactly what I was going to point to. In the 2021 order at paragraph 70, which is JA 113, we rejected a leverage argument from another party. I'm not going to try to pronounce their name because it's long and complicated. Noting that, we don't require PJM to exempt from forfeiture an effective FTR holder's positions where its virtual transaction position exposure is greater than its FTR exposure. We're not persuaded that these proposals are at this time necessary elements of a just and reasonable replacement rate. So we had earlier on said these are not necessary for a just and reasonable rate. The ultimate question we're trying to answer, and I think when you challenge our rate, again, I understand Judge Payne, you're making kind of an APA failure to explain challenge compared to an unjust and unreasonable rate challenge. But we had earlier on said, we don't think that's necessary for an ex-ante rule that is going to, try to catch cross-product manipulation. We just didn't think those were necessary provisions. We said it then. They came back and kept saying you can't be just and reasonable without these. And we again reiterated that. And as to kind of the explanation, my friend hit today that he hit in his reply brief and in his opening brief that in the rehearing order, we, discussed portfolio leverage, and portfolio of FTR arguments together. If you look at the rehearing order, and I apologize, we didn't include the whole thing in the JA, but it's available, it's in the record. In their second and third statements of error, which we include statements of error, it's their two merits arguments. If you look at the rehearing order, they switch between leverage and portfolio in the same paragraph after paragraph. I think it's pages, I want to say 10 to 13 of the rehearing order. But anyways, the point is they were addressing them both together in those challenges. We addressed them both in that paragraph, but there are earlier paragraphs addressing these various points.
But it seems that every time you address it, you say the same thing. We acknowledge that leverage may play a part in a cross-product manipulation, but it is not a necessary condition. And if that's not clear, it's not clear in every single order in which you've said that.
Yeah, I guess, I don't have a number of, like I gave the 2021 order citation, the next paragraph.
I'm looking at that.
We rejected a
right
test
now
for profitability. I think I would have to go back and look at those and see what, were we citing arguments the market monitor made, or et cetera. But, our ultimate question in 2017 was, is this just and reasonable? And we were looking at a few factors. In 2021, we narrowed that saying, we think a just and reasonable rate needs to have certain provisions, but doesn't need to have these others. And so, we didn't think catching Sienta, we didn't think catching kind of the profitability between the two markets were necessary to an ultimately just and reasonable.
I think it boils down to whether this sentence meaningfully addresses it, that it may play a part, but it's not a necessary condition.
And that's what I went to earlier. Yeah.
Exactly. And if that's not clear, then you haven't meaningfully addressed it. Because you say the same
Well, the
thing.
question is where the commission has referred to its previous decisions. Isn't that the incorporation by reference that this
Yes.
has acknowledged?
Yes, but in the previous
And here,
position,
it's
they
too
say the same
late
thing.
to seek rehearing of the 2017 and 2021.
Yeah.
In any event, we can discuss that later.
If you indulge me, I have one other site in my notes that's just in the 2017 order at paragraph 80, which I note is JA 38. We have rejected another party's, I think it was the, I don't know what the acronym stands for, but EDFT's argument for leverage, and the footnote there. Anyway, so the 2017 order does have some discussion of this. I appreciate your question, and again, that sentence specifically, I think, is capturing the idea. If you don't think that we explained it early on, that's obvious, but the idea that a just and reasonable rate doesn't need this component, it's an ex ante sort of forward-looking point. If the court has no questions, I realize I'm very far over. I appreciate your time.
Thank you.
Thank you.
May it please the court.
Yes.
My name is Jeff Mays. I'm counsel for the Independent Market Monitor for PJM. The core flaw in Exo Energy's case is that it has appealed the wrong orders: the 2022 order and the 2022 rehearing order. The 2022 orders on appeal address a single component of the FTR forfeiture rule, the impact test. The impact test is the only issue within the scope of the 2022 order. The EXO does not appeal the impact test. Instead, the appeal addresses findings on other issues addressed in the 2021 order that is not on appeal and in the 2017 order. EXO does not support its claim that an appeal of the 2022 order is proper. EXO Energy cites cases that are not about Ferc and RTO market rules. None of them are on point. The 2021 order is not abstract. It defines the scope of the compliance directive. Exo Energy's arguments are all directed at the 2021 order. And FERC counsel earlier noted a decision in the unpublished in Louisiana Public Service Commission versus FERC, where this court found that the PSC's failure to appeal an earlier FERC order was not final. So at this time, I'd like to make myself available for questions, including.
Well, do you
I
agree that there?
noted, sorry.
Go ahead, Judge Rogers.
No, Judge Charles, please proceed.
Okay, two questions. One is just your position on the remedy issue, and then also with respect to whether there's a violation of the filed rate.
We didn't take a position on the remedy issue. Our concern here really is to protect the FTL forfeiture rule. We think that is a very important rule for the efficiency of the markets and protecting against manipulation. We think such a rule always needs to be in effect as long as we have virtual trading in the markets. Having that rule is necessary in order to have virtual trading in the markets, and arguably even to have the two-stage day-ahead real-time market construct that we have.
Let me ask you, counsel, I read your brief. I didn't see that FERC adopted that position of forfeiture. Am I incorrect? Not that you don't state a forfeiture rule that this court has long recognized, that final rules cannot be collaterally attacked after the time for petitioning for review has expired. But did FERC pick up on that argument at any point? And I didn't hear it this morning either.
Yes, in the 2017 order, these issues, the issues in this case, were raised by Exo Energy and perhaps were also raised by others. And a decision was made, a final decision, that those elements, those components are not necessary for a just and reasonable FTL forfeiture rule.
Right. But
So
why would FERC not have picked up on this argument? I just wasn't clear about that because your brief was so definitive on this matter.
Right, I don't know why Ferc didn't argue
All
that as far as we did, but I would point to the 2017 order and the 2021 order. In the first compliance round, Ferc basically states in its order that the arguments being raised by EXO here, that they're not properly part of the compliance proceeding. And so I think that is, it's not in the current briefing stage, but in that 2021 order, I think Ferc is saying essentially the same thing that we're arguing.
Thank you.
Thank you. Anything further?
No.
Okay, thank you.
I'd like to begin by taking a crack at the question that Judge Rogers just asked. I think the answer as to why the commission didn't adopt the IMM's argument is that this is not a collateral attack on a final rule. The rule was approved only in the order that is now on review. There were aspects of the rule that were passed, of other proposed rules, I should say, that were passed upon in earlier orders, but we had no obligation, and the commission did not say in its brief that we had any obligation to seek rehearing of those orders in order to preserve our arguments as to the final rule, which is now properly on review in this court. So
Would you agree, though, that this court, given that Ferc has referred to these actions it took previously in 2017 and 2021, that this court has traditionally looked for the explanation provided by the agency, and a reference is sufficient? In other words, when the agency has decided 1, 2, 3, it doesn't, in the fourth situation, also have to redecide 1, 2, 3. It can simply refer to the orders on 1, 2, 3. And to the extent that the court is concerned about an adequate explanation, the court looks to the orders 1, 2, 3.
Yes, Your Honor. I don't take objection with that principle at all.
Thank you.
The issue here is that if you look back, what you're essentially getting is 0 plus 0 plus 0 plus 0 equals 0.
No, I understand that is your position, but that is not the agency's view of what it previously said. So your position in challenging the current order is that the court essentially is obligated to look at what authorities the agency cited, including its prior decisions that address issues you have raised in this appeal.
Yes, I completely agree with that, Your Honor. And on the portfolio issue, if you scour the record and look at all the orders, including the ones that are on review and the ones that were previously issued, you will find a rationale that's essentially market participants will have an incentive to manipulate a smaller FTR for the benefit of a smaller FTR, even if it's going to cause them to lose money on their overall portfolio. And as we explained in the brief, that doesn't make any sense. If you look back at all the orders, what you'll be left with on the leverage issue is a few orders that seem to conflate the leverage in the portfolio issue. And then I believe 2 orders that, possibly 3 orders that repeat the sentence about leverage being, a factor, but not entirely determinative. And
isn't it correct, though, that you presented those 2 arguments basically together and not in these separate ways that you are explaining them and your meaning regarding these terms in response to Judge Pan's questions?
I wouldn't concede that, Your Honor. I think we presented them as independent arguments, and I think they're inherently independent arguments. They cover different subject matter. As I acknowledged earlier, they're certainly related concepts, but they're independent arguments. And the commission...
Well, I understand that it's a different argument to say that something is blue and something is inequitable. But on the other hand, if you say not only is this order arbitrary and capricious, for a number of reasons. It's also arbitrary because it's blue and the other factor. That's all I'm getting at. In other words, it's not as though you tried in this appeal to get the kind of decision from Ferc to just repeat. You disagreed with it, but as Ferc said on rehearing, here are the arguments you presented on rehearing, and that's what we're addressing.
I think if you look at Ferc's brief in this court, their contention isn't these were all jumbled together, we didn't understand them, and so we gave a jumbled together response, and you should affirm because the arguments were presented in a way that was jumbled together. Their response is, on the portfolio issue, you would have an incentive to manipulate regardless of your portfolio. As we covered, that doesn't make any sense. On the virtual issue, they offer a rationale for their decision on the on the leverage issue. That again, what we hear today is an extreme elaboration on anything that we saw in the briefs or in the orders on review. The orders on review don't have a thorough explanation of their reasoning, don't provide any basis on which to conclude that their reasoning was either rational or irrational. They just state a conclusion, essentially, and that's not enough under Chenery. And to the question that Judge Pan asked earlier on, and Judge Schultz asked as well, on should the court remand or vacate and remand, our position is on the portfolio issue, there's really no way that on remand the agency is going to find the same way if they're forced to provide a rational explanation. And sort of basic APA Chenery principle is that we don't just assume that the agency would reach the same result. If they provided reasoning that is irrational, there has to be some kind of showing before the court takes the step of remanding without vacator, which would leave in place a rule that has no justification for it, subject to the future actions of the agency. And I don't think it's a safe assumption in this case that if this were remanded to the agency, they would in fact come up with a rationale for the rule that they've adopted.
Well, that must be premised on your proposition that the agency was required to adopt your analysis. And the agency specifically on rehearing said it disagreed. And so to explain why it disagrees, we can look at what it said about this very issue. That's all I'm getting at.
Certainly under Chenery, you can look at what the agency said about the issue in the orders on review and the prior orders. But to the extent those don't provide a reliable indication that the agency will...
I understand that. I understand that. Yeah. Okay. Thank you.
If there's something further. Thank you, Your Honor.
All right, the case is submitted.
Case number 22-7109, United Association of Journeymen and Apprentices of the Plumbing and Pipe Fitting Industry of the United States and Canada, appellant, versus Gemma Power Systems, LLC. Mr. Famia for the appellant, Mr. Silvestri for the appellee.
May it please the court. My name is Nicholas Femia. I'm here on behalf of the appellant, United Association. United Association appears before the court in challenge to a lower court opinion that declined to enforce an arbitration award and granted the motion to dismiss filed by appellee Gemma. It's our position that the lower court committed reversible error by applying the wrong arbitrability standard, and also by concluding that Gemma had no obligation to arbitrate its dispute. Arbitrate its dispute with the United Association. I have reserved 2 minutes for rebuttal, so I just wanted to note that initially. If the court would permit me, I'd just like to take a minute to set the framework for the legal discussion. This case involves a jurisdictional dispute, which the DC Circuit has defined as a conflict between two or more groups of employees over which is entitled to do work for an employer. In this particular case, the dispute is over certain piping work being done at the Guernsey Power Project in Byesville, Ohio. Moreover, this case involves a jurisdictional dispute that has been adjudicated by the Plan for the Settlement of Jurisdictional Disputes in the Construction Industry, which is a collectively bargained agreement between the Building and Construction Trades Council of the AFL-CIO, which is now referred to as North America's building trades unions, and 5 multi-employer associations The plan is designed to provide expedited resolution of jurisdictional disputes and ensure labor stability and peace on construction sites. For that reason, the plan specifically prohibits work stoppages, picketing, or other impediments to job progress, and establishes a contractually agreed upon mechanism for peaceful resolution of disputes. And I think this court has, in the past, recognized that there's a long history of courts in the NLRB recognizing the plan as a favored method of resolving jurisdictional disputes. Now, the plan's effectiveness in ensuring labor peace is obviously dependent on all parties, employers and unions, complying with the plan's arbitration decisions. And accordingly, the plan specifies ways in which unions and employers can become bound or stipulate to the plan. Stipulate is the term of art that the plan uses for just becoming bound to the plan. In the case of unions, if you're affiliated with the Building and Construction Trades Department, or if you sign a stipulation form committing yourself to being bound, or if you become bound via provision of a collective bargaining agreement, bingo, you're bound. In the case of an employer, it's a similar setup. You're bound if you are a member of an employer association which has stipulated the plan, or if you signed your own stipulation form, or you're bound by virtue of a provision in a collective bargaining agreement.
So in this case, it's the third for Gemma.
It's
correct?
the third. Our contention is that Gemma became bound via contractual provision.
Yeah.
The UA is bound
But
by
I
virtue of its membership in.
What's interesting about this case is that there is no collective bargaining agreement between UA and Gemma.
Yes.
Yet Gemma is seeking, yet UA is seeking to hold Gemma to something that they apparently didn't agree to in the JCUs that they did sign. So what is your best argument for why Gemma should be bound by what the arbitrator decided in this case?
Well,
because it's not based on the JCU that Gemma signed.
well, actually, the JCU in paragraph.
With 2 different unions, to be clear.
Yes,
Go ahead.
there are 2 different. I should clarify that. Yes, there are 2 JCUs, one with the Boilermakers and one with the Iron Workers.
Mm-hmm.
Both of those JCUs contain jurisdictional provisions, and there are 3 paragraph provisions. They're identical provisions, and the operative provision is paragraph 1. And paragraph 1, obviously.
Yes, I have it in front of me. That seems to apply to disputes between or among the union and other unions or any subcontractor. So that doesn't bind Gemma.
No, well, and
And
actually,
then it says decisions rendered under the plan shall be final and binding and conclusive on the union or other affected unions. That doesn't bind Gemma.
actually, Your Honor, if you read the provision, it says that what it essentially says is that all jurisdictional disputes, not just disputes picked by Gemma, but all jurisdictional disputes
Between
the union, i.e. the signatory union,
Mhm.
and any other unions who have signed agreements with Gemma covering work on the project,
Mhm.
or, and this is the operative phrase, any other unions who have signed agreements with any subcontractor governing work on the project.
But that's still between the subcontractor, which is UA, and the union and other unions. It's still not
Well,
Gemma, is it?
I think that the record reflects that the UA has worked on the Guernsey project pursuant to agreements with subcontractors.
No, I understand.
So the UA is covered under that provision. So this
For
this
disputes
specific,
with unions, but not with Gemma.
it's first of all, the UA is covered by that provision because it's worked on the project with subcontractors.
Wait.
And this provision specifically covers jurisdictional disputes.
If I could play out what I think happened, which seems to be in line with what paragraph 1 requires. UA, which is a subcontractor, I guess had a dispute with the unions, I guess the Boilermakers and the ironworkers, about jurisdiction to perform plumbing work on the project. And so the arbitrator rendered a decision, said that UA should get the work, and that's binding on the union and other affected unions. So now the Boilermakers and the ironworkers can't do the work. But Gemma went and hired non-union workers to do the work. Gemma seems to be in compliance with this JCU.
Well, the UA is not a subcontractor. The UA is a union working for a subcontractor on the project. And so
But that's how UA even gets in the door, right?
that's how the UA gets into that authorizes that clearly puts the UA in a position to file a complaint under the plan.
Right. So why is my reading of what happened not correct? It seems that Gemma is in compliance with paragraph 1. There were jurisdictional disputes between UA and the Boilermakers and the ironworkers.
Right.
There was an arbitration. That arbitration is final and binding on the unions. Gemma said okay, and they hired somebody else to do the work.
Well,
why is that not completely in compliance with this?
I guess you focused on actually there are two provisions of the jurisdictional dispute provisions that the district court mentioned. One is final and binding on the unions. Our contention is that if you're incorporating
part of the contract,
I'm sorry,
unions that are part of the agreement.
but if you're incorporating the plan into your agreement, you're incorporating it by reference. That means you have to go beyond this particular contract and look at the terms of the plan and who that covers.
But if anybody is covered, why is there an offering to be part of the collective bargaining agreement?
I'm sorry, say that again.
If anybody essentially is going to be covered, why is there necessary for there to even be an offering to the UA in this regard, which they refuse to be a part of?
Yes, I mean, I would argue that the fact that there is no collective agreement between the UA and Gemma isn't really relevant for these purposes. The fact of the matter is the UA can file a plan complaint under this language. The plan itself is a contract between Gemma and the UA. With regard to again, addressing your issue with regard to the question of it being binding only on unions, again, I would argue that if you're stipulating to the plan a collective bargaining agreement, you are in fact incorporating the plan into your agreement. And there is case law which I think backs up that claim, cited in our briefs.
But with respect to the people that you're in a collective bargaining agreement with, the only reason we began by saying Gemma is subject to the plan based on the collective bargaining agreement. That's how they're subject to the plan in this case.
Right.
And it has complied with this collective bargaining agreement, according to paragraph 1. So I don't see what the issue is. And my question for you is, under your reading of this provision, can any random union that's subject to the plan come in, demand work from Gemma? And if Gemma says no, they can go to arbitration and try to bind Gemma to hire them? Because that seems to be what's going on here.
No, it's not any random union. It's any union that is bound to the plan.
But that's almost all unions, isn't it? Building construction unions, because you can be bound to the plan just by membership in building and construction industry.
Yes.
So that just seems very broad and not consistent with the terms of arbitration. You only have to arbitrate based on what you've agreed to arbitrate. That's sort of a basic principle. So why do you have to arbitrate with any random union that comes in and wants work?
Well, I think in part because the paragraph 1 clearly allows the UA to file a plan complaint because it is working on the Guernsey project as for a subcontractor.
But it doesn't bind Gemma.
The plan provides for final and binding resolution
Among unions.
No, it's the plan is a contract between the Building Trades Department and multi-employer associations. Employers and the unions become bound to it individually.
So what's your best argument for binding Gemma based on the plan and the JCU?
I think it's a number of things. I think the jurisdictional disputes provision clearly incorporates the plan, and it incorporates it by reference. The plan basically says that that it issues decisions that are final and binding, I believe that answers your question.
Isn't your argument though that because Gemma and what I'll call the parent UA entered into an agreement that any subsidiary union of UA gets the benefit of that agreement? In other words, the subsidiary union here is not a random union, but rather it gets the benefit of its parents' agreement with the employer at issue. Or have I misunderstood your argument?
Yes, the plan is
Yes, I've
mechanism.
misunderstood your argument, or yes, I'm accurate.
No, I think that's accurate, Your Honor.
UA is a subsidiary of which union that's in an agreement with Gemma?
I'm sorry, the UA is bound to the plan. Its local unions, its affiliated local union, worked on the Guernsey site for a subcontractor.
That's not the question.
Okay.
I thought maybe I misunderstood Judge Rogers' question. I thought she said if UA is the subsidiary of a union that has entered a contract with Gemma, then UA may benefit from that. But factually, and you said yes, but factually I'm saying which union is UA a subsidiary of that has entered a contract with Gemma?
Right, I think I misunderstood the question. UA is not a subsidiary of the Boilermakers.
The other way around. Yeah. So what is your answer now that you understand and you say my question is based on a false premise?
I'm not sure I understand your question, Your Honor.
Do you understand Judge Pan's question?
Can you restate the question, Judge?
I guess my question was, what is your best argument for how UA gets to bring this action when it does not have a collective bargaining agreement with Gemma and is, I guess, not a subsidiary of the Boilermakers or the Ironmakers that do? And I think you're saying it's a subcontractor doing work on the Guernsey project. But I still don't see, as a subcontractor, how UA gets to bind Gemma. because it's not within the terms of the JCUs that Gemma did sign with the Boilermakers and the Ironworkers Union. And it appears that UA is not a subsidiary of the Boilermakers and the Ironworkers.
Right,
So
right.
I still think you're a random union coming in trying to bind Gemma. I think that you dispute that, but I'm trying to understand what's your best argument for why that's not the case.
Right. I think the point we're trying to make, Your Honor, is that there is no requirement of a collective bargaining agreement between. That's kind of a red herring argument. There's no need for a collective bargaining agreement between UA and Gemma in this.
But that's the only thing that binds Gemma to the plan, the collective bargaining agreement with the Boilermakers and Ironworkers.
Yes, that binds Gemma to the plan.
That's the only way that your client gets to enter arbitration with the other union, the collective bargaining agreement.
Right.
Could Gemma, UA not have had a direct action against Gemma, just contractually through NLRA or some other method?
The point is that the plan itself, once parties stipulate to the plan itself becomes a contract between the parties. And under the terms of the plan, the UA was well within its rights to seek a plan arbitration and enforce plan arbitration.
And you say once the parties, though, to the contract, which UA is not a party to the contract.
Yes, the UA is not a party to that particular agreement, but it is covered by, it is allowed to seek plan arbitration pursuant to that agreement. It sought the plan arbitration and it got an award under the terms of the plan. The parties, the decision is final and binding, and it's binding on all the parties. And our argument is that the plan's terms are incorporated by reference.
And I don't
Into
think
the
that
agreement.
The outside agreement between UA and the subcontractor is part of the record, correct?
It's not part of the record, but it is in the record that the UA works on jobs with subcontractors on the Quincy project.
I guess that's kind of.
That's not a matter of dispute.
Right, but I guess it's kind of begging the question about whether or not there were some remedies in that contractual relationship.
No, our point is that all the parties were stipulated to the plan. The UA pursued the case under the plan. The terms of the plan make it final and binding on all parties, including Gemma.
We've also got a statement in the record that essentially states that if UA had signed the document, then the other unions that are part of the plan would have relinquished their rights with respect to this jurisdictional dispute. And so, at least in that regard, these other unions also believe that UA would have needed to be part of this agreement.
The other unions, well, I don't think the other unions took that position. I think what happened here is that the work was assigned to these unions because the UA was not signatory to an agreement with Gemma, and then but the UA, oh, I'm sorry. think the
Was there anything else that you wanted to add? You know, you answered our questions, but was there anything else that you wanted to add?
not at the moment. I'm going to reserve time for rebuttal, though.
Okay, thank you.
Please, the court. Good morning. My name is Steve Silvestri. I'm representing Gemma, who's the respondent appellee in this case. Since 1960, in the Steelworkers Trilogy, the United States Supreme Court has ruled, it's been the law of the land, that the only way you arbitrate a dispute between a union and a company is that there has to be an agreement to arbitrate that dispute. And that has been the case all the way through since 1960. This matter here proceeds from a project, a large construction project in southeastern Ohio. It's a gas-fired power turbine power plant that was being constructed in a relatively remote place in southeastern Ohio. So Gemma is a project constructor, and before starting construction, it attempted to negotiate ADF pre-hire agreements, which is legal under the NLRA in the construction industry, ADF pre-hire agreements with the trade unions because it needed skilled labor to perform that work. In particular, the disputed work in this case doesn't involve normal plumbing. It involves high-pressure welding of gas and steam that's coming through that. So it needed skilled labor. Gemma was also concerned as it started this project that it wouldn't have enough, because it was a years-long project, wouldn't have enough skilled labor to complete it. The unions wouldn't be able to supply enough labor, whether it was volume or skill sets. So there are provisions in the job compliance agreements, the JCUs, these are the collective bargaining, that Gemma installed and negotiated with the Boilermakers and with the iron workers that permits Gemma to assign work to other source labor, to outside, to subcontractors, to non-union labor in the event that they didn't have skilled labor or there wasn't enough people. And so that's how this case started. So at the beginning, it negotiated a job compliance understanding, a collective bargaining agreement with the iron workers. It negotiated a collective bargaining agreement with the Boilermakers. And it attempted to negotiate a collective bargaining agreement with the plumbers. And it offered the plumbers the same agreement, essentially the same agreement that the iron workers signed and the boiler workers signed, but the UA didn't sign it. So when the project started, they got to the phase where they were doing high pressure welding. Gemma assigned that work and asked the iron workers and the Boilermakers to do that work. And they proceeded to do that work. And then this case started after that. So then there was a demand to arbitrate before the plan. And Gemma took the position at the plan that it didn't have jurisdiction. One, because it hadn't signed a collective bargaining agreement with the UA. And Judge Rogers, there is nothing in the record. There's no contract in the record between Gemma and the International Plumbers Union or any other record that binds Gemma to the plan. Okay, there's no contract whatsoever. So the case proceeded in the plan. Gemma took the position that the plan didn't have jurisdiction. We didn't appear in the plan, didn't file any positions, didn't offer any evidence. There was two arbitrations. The first arbitrator basically said, look, there's no collective bargaining agreement. I don't have any authority to assign the work to the UA because you don't have a collective bargaining agreement with Gemma. There was an appeal or review process. The second arbitrator, a gentleman named Ferc, decided, one, that he had jurisdiction over Gemma, and two, he ordered Gemma to assign the work to the UA. Problem was, and the problem is, that there is no underlying collective bargaining agreement, either an ADF pre-hire agreement between Gemma and the UA, or a post-hire, like Section 9, regular collective bargaining agreement between Gemma and UA. So the issue here in this case is whether or not the plan had jurisdiction over Gemma and whether or not its order to assign work to Gemma violates federal labor law, which I believe it does, because it essentially imposes a collective bargaining relationship between the UA and Gemma that doesn't exist and has never existed in this project. So So Judge Kohler-Patelli rendered a decision, and again, our position before the district court was not only Jason didn't apply here, didn't bind Gemma to the decision of the tribunal, and we didn't see to the jurisdiction of the tribunal with respect to the UA, but also there's a variety of NLRA violations in connection with the award by the plan. So the district court cited 4 provisions in the JCUs that are relevant here. First is paragraph 1 of the JCUs, which is record 033. It says that Gemma can assign work to subcontractors or other source labor at its discretion as it needed. That's number 1. Number 2, at 034 of the record, there's an integration clause, which is really important because my friend is arguing that somehow there's another agreement where the plan itself provides jurisdiction. So there's an integration clause here that says that the only agreement between the union, the ironworkers and the Boilermakers, is that JCU. There's no other agreement that comes in. Very important, I think, provision in the district court's decision. And then number 3 was that there's the work jurisdiction language, which is in the supplement in the back of the JCUs that talks about paragraph 1, which is the unions can arbitrate their dispute between themselves in terms of jurisdiction with the plan, but Gemma is not bound by the plan, and the plan's provisions or the plan's decisions are binding on the unions, but not on Gemma. In fact, the 3rd paragraph of the JCU specifically says that Gemma retains the right to assign the work to other source unions or to others as it sees fit. So that's a contract, and that's what's in front of the court right now. So, our position is that the district court's decision was based on a clear and unambiguous language of the JCUs. That the judge did not apply the wrong standard. There's a clear and convincing discussion in the district court's decision, but actually it was, if you look at it, what the judge was commenting on was the other arbitration provision in the JCUs, the violation of the agreement. You didn't pay the right rate or you didn't pay benefits. That's a general arbitration, grievance arbitration provision in the JCUs that isn't even relevant here because this is not a contract between the UA and Gemma. So basically our position really is that there's nothing else in the record that the UA could rely upon to somehow bootstrap or jump into jurisdiction with the plan. And therefore, the plan had no jurisdiction here, and the order of the plan should be vacated. So we ask for affirmance of the district court's decision. If you judges have any questions, I'll be happy to answer.
Anything?
Thank you.
Okay, thank you.
Your Honors, I apologize for perhaps misunderstanding your questions earlier. Let me restate my argument.
This is counsel for appellants.
Yes, Your Honor. Gemma claims that the UA can't point to any language to support its claim. But I want to reiterate that Gemma's JCU requires all jurisdictional disputes, even those involving other unions that have collective bargaining agreements with subcontractors, to be submitted to the plan. This evinces Gemma's agreement to submit all jurisdictional disputes to the plan. Moreover, and this is the point I was trying to make earlier, Gemma's incorporation of the plan into the JCUs logically requires consideration of the plan's provisions. And this expands the arbitrability analysis beyond the JCUs. The Supreme Court has held that to interpret a collective bargaining agreement, it is necessary to consider the scope of other related collective bargaining agreements, as well as the practice, usage, and custom pertaining to such agreements. This consideration is especially appropriate where the collective bargaining agreement in question incorporates other agreements by reference. And that's a point that's been made by the DC Circuit and BP Amico Corporation. BP held that collective bargaining agreement may incorporate another document by reference without using that phrase, if the collective bargaining agreement evinces an intention to make that document part of the agreement. And in this particular case, Gemma has very clearly agreed to submit all jurisdictional disputes, including jurisdictional disputes involving unions that work for subcontractors on the Gwenzy project, to the plan. And if we make an excursion into the rules and regulations of the plan, we see that it says that this decision of the arbitrator shall be final and binding on all parties to the dispute.
I guess, though, the argument would be that Gemma is not a party to this dispute. Because
well,
under the JCU, it's disputes between and among unions and other unions.
It is a party to the dispute, and the contractors are always parties to jurisdictional disputes. There are parties to the contractor is a party to a jurisdictional dispute under the specific terms of the plan. In fact, a contractor can initiate plan cases under the
With respect to unions that they've entered a collective bargaining agreement, but not with respect to others.
I think the larger point here is that the collective bargaining agreement doesn't have to be between Gemma and the UA. The plan simply requires that the parties be bound.
But I think the fundamental issue is Gemma entered collective bargaining agreements with these two other unions. And there is a provision within that collective bargaining agreement, this JCU, that does allow UA to dispute jurisdiction among unions, which it has done. But then this JCU says that the decisions rendered are final and binding on the union and other affected unions. So this JCU doesn't bind Gemma to abide by what the arbitrator said. And to the extent Gemma is part of the plan, it never intended, to the extent that we are looking at the rules of arbitration, it never intended to be bound to an arbitration with Gemma, who's nowhere mentioned in this JCU.
With UA.
I mean, with UA, right.
My point is, Your Honor, that Gemma bound itself to the plan by virtue of this provision, and in doing so, it incorporated by reference the terms of the plan itself. And under the terms of the plan itself, Gemma is in fact bound to arbitrate with the UA, and it is bound to treat that arbitration as final and binding, and to comply with it. The terms of the plan also authorize the UA to seek enforcement of the arbitration award, which is precisely what it did in this particular case. The other language, and I want to address this, the other language that the district court relied on was a language in paragraph 3 of the jurisdictional disputes provision, which refers only to other source labor or non-union labor, which is not even applicable to this dispute, which involves union represented employees. And it says that Gemma retains the sole right to control and assign the jurisdictional duties of all work. Even if that provision is meant to relate to the entire jurisdictional dispute section, under the plan, it doesn't infringe, the plan award doesn't infringe on that right. Under the plan, a contractor has the sole right to assign work to employees represented by a particular union in the first instance, and is required to continue that original assignment unless otherwise directed by an arbitrator or there's an agreement between the unions. As noted, the JCUs also mandate that employer assignments be followed until the dispute is resolved on the plan. So the JCUs retain the sole right to control and assign the jurisdictional duties for all work provision is necessarily limited to the initial assignment of work and is subject to change mandated by a plan arbitration decision. So that's the way the plan works, and that's the way this provision works. You're supposed to, the jurisdictional disputes are covered by the plan. Paragraph 1 specifically says that assignments are to be kept in place until the plan rules, which, is obviously an implicit acknowledgement that the plan governs. The plan has the ability to make a decision as to all jurisdictional disputes, including jurisdictional disputes between Gemma and the UA. If Gemma, let me also point out that there is nothing in that jurisdictional dispute provision that expressly exempts Gemma from plan arbitration or compliance with the plan. In fact, in its briefing, Gemma actually says that the provision expressly, they use that word, expressly, excludes Gemma from plan arbitration, from compliance with plan arbitration. It does not. The language does not do that. And if Gemma wanted to exclude itself, it easily knew how to do that, because in the third paragraph, you'll see it. They do make a point of excluding anything involving other source labor from the plan. But they don't do that with regard to disputes between unions and union represented employees. So, the standard under the Steelworkers Trilogy, and that is the applicable standard here. The standard used by the lower court, the particularly clear standard, was obviously inappropriate. She took that from Wright v. Maritime, a case that involved whether a statutory claim could be required to be processed under arbitration, a collective bargaining agreements arbitration. And that's not the case here. But we're not talking about statutory claims in this case. So what you have here is the district court analyzing this jurisdictional dispute provision pursuant to an improper standard. The proper standard is provided by the Steelworkers Trilogy. And the Steelworkers Trilogy, which recognizes the public policy in favor of arbitration and the way it maintains industrial peace, makes it very clear that if you want to avoid the responsibility to arbitrate, you need forceful evidence, positive assurance that you are excluded. And I would argue that there's nothing in this jurisdictional dispute provision that constitutes forceful evidence that Gemma is not obligated to arbitrate this dispute. I would also point out that both arbitrators in this case concluded that Gemma was in fact subject to the plan. Not just the arbitration that's at issue here, but even the first arbitration to which my friend referred. Both of them concluded that in fact this was arbitral and Gemma was bound. I realize that the court doesn't have to defer to an arbitrator's opinion, but I think the case law suggests that the arbitrator's opinion should be taken into account.
The first arbitrator did not find Gemma bound.
Excuse me?
The first arbitrator did not find Gemma
Yes,
bound.
he did. What he found was that all the parties were subject and bound to the plan. But then he went through
Gemma wasn't bound and Gemma appealed, and then you got the second arbitrator that
No.
favor.
No, what happened was the first arbitrator concluded that all the parties were bound to the plan. But then in going through the decisional criteria of the plan, he said, well, there's no collective bargaining agreement here. So even though the decisional criteria of the plan would suggest that it's the UA's work, I'm not going to apply those criteria. So he didn't say that Gemma was not bound to the plan. In fact, he found that it was bound. The second arbitrator specifically found that Gemma was bound and pointed out there's nothing in the plan that requires a contractor to have a collective bargaining agreement with one of the contending unions. There's nothing in the plan that requires that. And Gemma knew that when it incorporated the plan into its collective bargaining agreement. It knew that, and it accepted that term, just as it accepted all the other terms, which as I mentioned earlier, are incorporated by reference into this agreement, including the terms of the procedural rules and regulations of the plan that say that these decisions are final and binding, the provisions of the plan that say that the parties to the dispute are required to comply with the decision of the plan. I don't think Gemma can have it both ways. They obviously wanted the plan. They included the plan in these JCUs. They drafted these JCUs because they wanted the advantage.
Why isn't it that Gemma's bound to the plan with respect to the unions that it signed the JCUs with?
I'm sorry, I didn't hear you.
Why is it not that Gemma is bound to the plan with respect to the ironworkers and the Boilermakers? Because that's who they signed the JCU with. Period.
That's not how the plan works. Once you stipulate to the plan, once you stipulate to the plan covers you comprehensively.
But what if there's a conflict between what the plan says and the JCU?
I think if you're incorporating the terms of the plan, if you're consciously adopting this mechanism, which offers tremendous advantages to Gemma because it bars and picketing, work stoppages, impediments to job progress. If you're incorporating that, then you buy the whole package. You buy the package that says that you're bound to any plan decision. You buy the package that says these decisions are final and binding on you.
But you only get those benefits.
They can't have it both ways.
But you only get those benefits with respect to the unions that you have collective bargaining agreements.
No, they're obviously seeking those benefits with regard to other unions too, because the jurisdictional dispute provision covers disputes with other unions on the project that have agreements with subcontractors. It's Gemma that agreed and drafted this provision that brought the UA within the ambit. And it's obviously Gemma thought it was in its interest to ensure that any jurisdictional dispute between the Boilermakers, the ironworkers, and any other union on the project should be resolved peacefully pursuant to the terms of the plan.
Thank you. I think I understand.
Okay, thank you. Anything further, Judge Rogers?
No, thank you.
Thank you. The case is submitted.